Good morning, everyone. I want to welcome you from Warsaw, from sunny Warsaw, which hopefully is COVID-free, at least for this vacation. We have another coffee break planned for today. My guest is an IP professional. I will let him speak for himself in a minute. My name is Michał Barłowski. I'm a senior counsel with Barłowski and Partners in Warsaw. The purpose of our meeting today is to talk a little bit about the Polish market in terms of the insolvency practitioners' experiences and what are the latest in terms of COVID and the directive laws in Poland, and basically to wrap up a little bit what we look for in Poland and what's the general restructuring situation. So with this in mind, let's start our coffee break. My guest is a very experienced insolvency practitioner, Michał Nowicki. We know each other for a long period of time, but maybe I will let Michał speak for himself.
Good morning, my name is Michał Nowicki. I have been involved in bankruptcy proceedings, liquidation and arrangement proceedings for over 20 years. For several years, I was a member of the board Foreign Law Office in Poland. It was company specialized in bankruptcy law, and I also was a member of Insolvency.
Okay, thanks. So let's now move on to the first issue. We want to share with other colleagues from the IP profession. As far as I recall, the market of IP professionals is developing since 2016, because this is or 15 even, since this is the time when a new law was introduced in Poland to regulate the profession of an insolvency practitioner. Up to the 2015, the market was such that receivers, liquidators, were also dealing with restructuring proceedings, which were before 2015 an instrument available in law, but nonetheless the big boom occurred with the reform of law in 2016. So to give you some insight, I will now ask Michał, so how do you become an IP professional? You've been an IP professional for 20 years. So
I will explain. It is a legal profession for which qualification will be obtained experience and business management. Completed university studies is required. The period of practice necessary to obtain a license depends on whether you do have complete legal, economic, or other studies. It is also necessary to pass the state exam. After meeting all the conditions, you are entered of the central, it's very important, the central list of insolvency practitioners.
Okay, so clearly there is a benchmark to pass, as I understand. So tell us maybe a little bit about how you see the functioning of the market. I mean, how do you work? What are the basic issues these days? I mean, tell us about your practice.
Now I have some cases connected with new law based on COVID-19, because we have new procedure in Polish law. Maybe we will say some words about this procedure after next question.
Okay. One of the key issues, obviously, in any type of restructuring is the involvement of courts. So how do you see, your relation with the courts? Was it an easy thing, or because COVID obviously has blocked a number or delayed a number of proceedings, I think. So what's your perspective on this?
In this time where we have COVID, it's harder to cooperate with courts because it's hard to meet, and courts don't have a lot of time to contact with insolvency practitioners. So we can use a new procedure and we contact only with creditors and debtors, and we don't have to contact with courts, so it's easier to do it.
Yes, I mean, being a lawyer, I can confirm that the simplified restructuring proceeding, because this is the official name, and in Polish it's a short name UPR. We will sort of refer to that in a second. But in terms of the market, I understand that at the beginning of COVID, and this was the case in a number of EU member states, businesses have obtained state aid to support these businesses during COVID times. Now, obviously subject to the fourth wave of COVID, we do not know what's going to happen, but at least the main position or the dominant situation is that the time has come to return the aid that was given to entrepreneurs. And I hear from my colleagues from other jurisdictions that the fact that you have to return aid, which will result in a number of insolvencies and probably restructuring proceedings, which will need to be open to save businesses or to liquidate businesses, because they will simply not have generated sufficient income during the short post-COVID or during the COVID times to return the financial aid.
So I think that this procedure in Poland is very popular because we have about 70% all restructuring procedures is connected with this UPR in Poland.
Okay, but do you think that there will be an increase in the number of insolvency proceedings now, or you don't see this on the market, or what's your expectation? Will it be on the rise, or?
I think that some interpreters refrain from the restructuring activities until they receive a decision on the method of seeking the subsidy, because the opening of the restructuring proceeding before the statement of the COVID subsidy result is the need to return all the receipts. This is, of course, an emergency exit coverage of the subsidy granted by the state.
Okay, just to comment on your last point, I think it's obviously if your business cannot return the aid, it can be part of an arrangement. Sure, that's a solution. But referring to your first point, I think yes, there is some logic in this, because as I recall, at the time when aid was given, one of the conditions of obtaining the aid, the COVID aid, was that a business is not insolvent. Indeed, that's what was the case. But is there anything else you want to comment on this?
Yes. There is some logic in this, you said, but the fact that an interpreter needs to return the financial assistance so quickly when demand and given market and just picking up, and it's not clear what is the market future. It's irrational and may also prove that the financial assistance was not sufficient in the first place. In fact, a lot of state assistance in Poland has been recently redeemed, so interpreters do not have a duty to return the financial assistance obtained at the beginning of the COVID pandemic.
Indeed, that is a good point. The redemption obviously will I just think aloud that the redemption may also result in other fields of law problems, like redemption, whether it's taxable or not. I think we will have to look at this or leave this to other colleagues, or maybe tax professionals. Maybe now let's move on to the question of the restructuring directive, because all member states had a duty to implement it. And obviously, one can look at the directive from a different angles, and from the lawyer's point of view, from the creditors and debtors look at it, and what's your take on the directive? I mean, is it, for example, for the IP professionals, is it something they look for because of the facilitation, maybe in context between IPs with other IPs, or is it something totally indifferent? And you know, you do not talk about the directive with your colleagues or in the profession.
A number of European Union member states have applied for an extension by 1 year of implementation of the restructuring directive into its own legislation, and so has Poland. Today, the Polish Simplified Restructuring Proceeding, the Polish short name is UPR, has served two purposes. First, it was a reaction to the economic problems faced by interpreters due to the COVID. Economic restriction imposed on businesses, so a fast-track restructuring proceeding was welcomed. And the second role it played was to be a test ground how it practiced the UPR work and how the market react. UPR, together with already existing restructuring law, which complies in its fact majority with the restructuring directive. What is happening with the directive itself is not something really followed by insolvency practitioners, because there is a limited number of cross-border insolvency cases or group of companies proceeding cases. Yes. Thus, there is also limited experience which Polish insolvency practitioners have with foreign IPs. Hopeful that will change in time. And speaking for myself only, I would welcome a discussion with foreign insolvency practitioners, so as to agree a good practice code, kind of soft law set of rules, which would apply whenever a cross-border case needs to be dealt with.
I think it's a very good point you mentioned, because these days, from my perspective, soft law is becoming something of importance rather than just basing on hard law. And I think your point on the fact that any contacts and any relations with foreign IPs is welcome, and it's good to hear that. And hopefully, who watches this COVID coffee break, will see that that there is openness on the part of the Polish IP profession to contact foreign IPs. So thanks for this comment. I guess we are getting close to our conclusions from this meeting, and let me maybe start with the following. That to date, we have the simplified restructuring proceeding, which was a temporary measure. Now, since 1st of December 2021, we are going to have a new proceeding apart from the already existing 4 types of restructuring proceedings. So as you can see, the Polish restructuring law is well developed and has a number of options, ranging from simple proceedings to ones which are very close to insolvency. Now, with the directive, we have a compliant, or will have a compliant with the directive, new 5th proceeding. So that's something to take from our meeting today. The second thing, and the best proof, is that Michał is here and with us. We have a very well developed IP market. IP professionals no longer defend or liquidate rather assets, but the rescue mentality approach is well developed now in Poland, and there's a lot of experience with generated with rulings with professionals, IP professionals. We look forward to the new law. We will see what's going to happen.
Yes, I think that we will have very good product, because well prepared simplified restructuring proceedings model seems to be a very good idea to use in other jurisdictions. The model offers great flexibility and protection and allows the debtor to choose a restructuring advisor. So in my opinion, it's very important. And the limited duration of such proceedings should result in a quick and specific action without having filters.
Thank you, Michał. I think that it may be late for Germany and who has the star run and for the Danish law, but maybe some other member states may want to look also at our simplified restructuring proceeding and maybe take the best out of it in its own jurisdiction. Thank you again, Michał, for being with us. Thank you for your time. I know you're running to go to attend a court hearing case. So thanks, that special thanks to you, and thank you all.
Thank you for your invitation.
Thanks for your invitation, and thank you all for being with us. Bye bye.